Greetings, my fellow freedom lovers and sovereign thinkers. This is LL3's latest podcast. My name is Craig, and I am just lounging out in a little shopping area among the swampy mangroves of South Florida. Today is Monday, January 20th, 2014. And just chilling, had a hot dog under an umbrella. And today, I'm going to be narrating an article that was posted by Occupied Corporatism, Susan Possel's little pet peeve, I would say, and got some good articles and enough links to back it up. So I'll be narrating the topic entitled U.S. District Court, Citizens Journalists Have Same Rights as News Media. That will drive people like Dianne Feinstein and Charles Schumer crazy because they know they're being exposed, just how corrupt and pathetic they really are. So, let us begin. This was actually released on her page today. And now, I'll proceed. The 9th District Court of Appeals, Circuit Court of Appeals, ruled last week that bloggers have the same First Amendment rights as established journalists when involved in a defamation of character suit, as long as the issue is of public concern. The outcome of this case establishes the fact that protections afforded the news media are not exclusive to their realm, but also extended to citizen journalists and bloggers. The decision was entered because of a defamation lawsuit brought in Oregon concerning a blogger who had written online that this person had criminally mishandled a bankruptcy case. In this instance, the trustee was not a public figure. However, it was ruled that this case is of public concern and the negligence standard was applied. 2 years ago, Crystal Cox, an investigative blogger, was sued by Kevin Patrick for writing online that Patrick was guilty of fraud, corruption, money laundering, and other illegal activities. U.S. District Court Judge Marco Hernandez originally denied Cox the right of journalistic protection. A new trial was ensued as the appellate court dismissed the ruling of Judge Hernandez, paved the way for a new trial for Cox. The three-member judicial panel, headed by Judge Andrew Hurwitz, wrote Cox apparently has a history of making similar accusations and seeking payoff in exchange for retraction. Hurwitz continued, because Cox's blog post addressed a matter of public concern, even assuming that Gertz is limited to such speech, the district court should have instructed the jury that it could not find Cox liable for defamation unless it found that she acted negligently. We hold that liability for defamatory blog posts involving a matter of public concern cannot be imposed without proof of fault and actual damages. Most importantly, the judge found that under the First Amendment, it doesn't matter whether the person accused of defamation is a professional journalist, an amateur whistleblower, or a crank with a webpage. This case highlights the findings of 1974, wherein the U.S. Supreme Court wrote that freedom of the press applies to everyone, not only journalists. Eugene Volokh, professor of the law at the University of California at Los Angeles, commented on the Cox case. It makes clear that bloggers have the same First Amendment rights as professional journalists. There had been similar precedents before concerning advocacy groups, other writers, and book authors. This follows a fairly well-established chain of precedents. I believe it is the first federal court of appeals level ruling that applies to bloggers. This case is important to the future of citizen journalism because of the crusade against the freedom of speech being perpetrated by members of Congress. Senator Dianne Feinstein commented last year that a new media shield will guarantee First Amendment protection to federally recognized journalists who are real reporters, not those blogger journalists in alternative media. Feinstein claiming that the First Amendment is a privilege, not an inalienable right as defined by our U.S. Constitution. So where she studied constitutional law from? A Cracker Jack box? The Federal Media Shield, FMS, aka the Free Flow of Information Act, FFIA, states, conditions for compelled disclosure in any proceeding or connection with any issue arising under a federal law. A federal entity may not compel a covered person to comply with subpoena, court order, or other compulsory legal process seeking to compel the disclosure of protected information, unless a federal court in the jurisdiction where the subpoena, court order, or other compulsory legal process has been or would be issued determines. After providing notice and opportunity to be heard by such covered person, there is a stipulation that governmental party seeking to compel disclosure of the protected information must have exhausted all reasonable alternative resources other than a covered person of the protected information. The definition of a journalist is included in the text. The committee defined a covered journalist as an employee, independent contractor, or agent of an entity that disseminates news or information. The individual would have been employed for a year within the last 20 or 3 months within the last 5 years. It would apply to student journalists or someone with considerable amount of freelance work in the last 5 years. A federal judge also would have the discretion to declare an individual a covered journalist, which would be granted with privileges or laws. I'm sorry, I think this is more like a comedy show. Where she get her one-liners from? Gary Shandling? Please. The definition does not include any person or entity whose principal function, as demonstrated by the totality of such person or entity's work, is to publish primary source documents that have been disclosed to such person or entity without authorization, meaning that journalists within the alternative and independent media are now not considered covered journalists or even journalists at all. Oh man, well, that's another Khazarian Jezebel, Senator Dianne Feinstein. You don't really have a damn clue. You're in your own pathetic little world and believe we should look up to you because you're an attorney by trade. So what? That's all I have to say. Another useless body count. She's not even a senator. She's more like a pathetic stooge as far as I'm concerned. But that's the fact, my friend. Bloggers, citizen journalists have the same protection under the First Amendment of the U.S. Constitution. The stupid little law Dianne Feinstein wants to author, she can stick it up her rectum for all I care, and deep down inside she knows I'm right. And if you support her, support that cause, what she's doing, I'm calling you out. You have the guts to write me, all right? You could hit me on Facebook, Twitter, YouTube, it doesn't matter. I want to hear your point of view on why you defend Dianne Feinstein's tyrannical concept. So, that's all I have to say. And remember one thing, my friends, the Bill of Rights stands for government keep out. That includes her, Dianne Feinstein, and her pathetic cohorts. Well, that's all for the time I have for now. And I do thank you for your time. Hit me on Facebook, Twitter, or YouTube. Give me your comments. Middle fingers. Ups and downs. Criticize me all you want. It's all right by me. And final note, demoniac resistance is healthy for the soul and can liberate societies. Until next time, take care of yourselves and may your guardian spirits be with you.